So hi everybody, good morning. Like Bea said, I'm Launi Stone. I'm a victim advocate at Utah Crime Victims Legal Clinic. I actually have Beatrice's old job. So I'm really nervous. This could end up taking 10 minutes and then we'll all get to go have a break. So um, like Bea said, I am really passionate about victim rights. I absolutely love this job. And I'm so grateful to Sergeant Williams at West Jordan City, who originally got me interested in being a victim advocate. But now working at the clinic is just absolutely phenomenal. And I really, really have developed a love and a passion for victim rights, but also just learning about it. It's the nice thing with being like the dumbest person in the room all the time, because I work with all attorneys, is that I'm always learning. So that makes it always interesting. So today we're going to talk about the victim experience in criminal court cases. And you guys are all victim advocates, so or do victim advocate work. So you know that the victim is not usually the most important person in a criminal court case, unfortunately. They should be, but victims have a lot less rights than defendants do, which we wish that was better. But so let's see. Uh-oh. I just messed something up. Hold on. Sorry, B, I'm sorry. Okay. Am I still sharing? Sorry.
You're on our end. Yeah, you're okay.
My bad, my bad. So rights in the criminal justice system have historically been mostly for defendants. It wasn't until the late 1970s that a few grassroots organizations started fighting for victim rights, the late 1970s. So now every state has laws regarding victim rights in criminal cases. There are over 28,000 laws in the United States. 33 states have constitutional mandates, and there are even assured victim rights in federal court cases. And there's, if you guys want to look up, there's the federal initiatives. It is interesting to know about. So the federal stuff is specifically for federal cases, but it is interesting to learn about that. So what does it all mean? Victim rights in Utah are all about dignity, notice, and participation. Okay. The Utah State Constitution Declaration of Rights of Crime Victims is pretty basic, but it's one, to be treated with fairness, respect, and dignity, be free from harassment. Upon request, be informed, present, and heard at important hearings, and to submit and have information considered at sentencing. Sorry. Getting more in-depth and specific, though, in the Utah State Code, Section 7737, it states that all criminal justice agencies shall ensure victims have the following rights. Now, that word shall is really important in legal and legislative circles. Shall means it will be done, not you should do this, not, oh, this is probably a good idea, this is how it should happen. No, this is absolute. Shall is like the end all be all in legal. So that's on my little slide there. And sorry, I have my slides like over here. So if you see me looking over here, I apologize. But we'll kind of cruise through the slides really quick, or the rights really quick, and then we'll kind of go a little bit more in depth with some of them. The first right is to be informed of threats. And this isn't one that I really have ever known a lot about until recently. This means not only is the victim to be informed of threats to their safety and well-being, but also that they will be afforded protection from those threats. The protection is through protective orders, law enforcement involvement, and other orders from the court. If anybody has like questions or comments, please jump in because I am probably going to need some help here. The next two rights go kind of hand in hand. These are the right to be informed and assisted throughout the criminal justice process, and the right to clear explanations of legal proceedings. This means victims, including children and their guardians, have a right to be assisted as to their role in the criminal justice process and clear explanations of relevant legal proceedings and the process. These explanations are expected to be done in a way that victims can understand, which means age-appropriate explanations for children and no legalese for other people. So legalese is just what we say for legal language, because legal language is it's its own language. If you don't know those things, then it might as well be speaking Greek. Or at least, that the language, the legalese should be explained well. I'm going to need some participation here, if that's okay, B. What do you think are some examples of legalese terms or ideas that victims might not understand if they have never been involved in the court process before? Throw them out there, ladies and gentlemen.
You got a hold.
Say that again.
Go
I
ahead.
think every single hearing is a word that most people haven't understood. So I think almost every term that's used is unfamiliar to most people. So in my
Very
experience,
much so.
yeah, my experience with working with victims in district court for many years is that a lot of times the public in general doesn't have interaction with the criminal justice system usually. And so what we think of is what we saw on TV. And that the judge does all these things and the judge makes the decision, well, they do make decisions, but I think the process is really hard. And then also I think for victims too, is when you come into a courtroom and you see the prosecutor and the defense attorney chit-chatting at the table. Maybe they're talking about their families or different things because maybe they know each other. And a victim can look at that and think something secretive is going on that they're not aware of. So I think there's just a ton of things, but the language to me, I think almost every term would be unfamiliar to most people. Prelim, hearing waivers, every arraignments, all of it.
Yes, and I don't know who that was talking, but
It was Holly Johnson.
oh, hi, Holly. So yes, 100%. I have had so many times when victims have got upset when they see the prosecutor and the defense attorney chit-chatting. And even though they're on the other side, most of the time they're pretty congenial with each other. Like, I mean, there's obviously exceptions because there's just certain defense attorneys that don't get along with anybody, but they are usually pretty friendly with each other, especially the LDAs, the public defenders and the prosecutors. They know each other really well because they're in court together all the time. So yeah, there is a lot of like chatting back and forth and laughing, and that can be really unsettling for a victim who hasn't ever experienced that before, feeling like there's something, back alley going on. And I think, Holly, you're 100% right. Like pretty much every term in there is something that people aren't familiar with if they haven't been involved in the court process before. And you mentioned arraignment, preliminary hearing. What are some other words or terms or things that you guys think people might not be familiar with? I have a list if nobody else wants to throw it out there.
When an evidentiary hearing,
Evidentiary hearing, yes, very much. And
investigation, or the show cause, those are the three, I think they don't understand.
I heard evidentiary hearing and then I didn't hear the rest. What did you say? I'm sorry.
A restitution hearing, and then when they're called to order to show cause, when they fail to comply.
Yes, very, very good. Evidentiary hearing is one that I had forgotten to write down. So awesome. Thank you. Anybody else have any terms? Plea in abeyance. That's a really good one, Kylie. Plea in abeyance is a little bit more common I think, in justice court. We do see it in district court. And you have to explain that. You have to explain what a plea in abeyance is to a victim. They have no idea. And they're complicated. Does anybody not know what a plea in abeyance is and need that explained? You can always put questions in the chat too.
Oh, do you mind if I say something about plea in abeyance?
Yeah.
So I think there's a huge misconception on a plea in abeyance. People think that the person has got off the charges, you know what I mean? Like they're not being held accountable. And so I think explaining the plea in abeyance is so critical for victims, how it would be beneficial for them, how they might, not telling them what to think, but just explaining in detail. The court is going to still be this charge is still over this person, you know, they're still being held accountable. They're just having the opportunity to not break the law for whatever, the next 18 months or something like that. You know, but if they did, these charges are gonna come back. So I think a plea in abeyance is very tricky for people because they get this thought that, oh, they're just letting them off on these charges. Just a thought on plea in abeyance.
Yeah, I totally agree. Lori, you have your hand up. Lori Jenkins, sorry.
That if a victim talks to one judge, that all of the judges in different courts don't know what they said to the one judge, because they think sometimes if you say it, then everyone knows, and that's not the case.
Very good point. I mean, there are notes and stuff that they can look at, but who knows if they ever do. So some of the words that I wrote down, just so you guys know, adjudication is a big one. My sweet Hillary that works with us, she was making a presentation to kind of explain the justice process to people, and she had adjudication on there, and I was like, you should probably not do adjudication, because I didn't know what that word meant until I started working as a victim advocate. But adjudication, probable cause, standard of evidence, hearsay, arraignment, pre-sentence report. That's a big one that needs a lot of explanation for people. Detention hearing, motions, order from the court, cross-examination, preliminary hearing is one that Holly mentioned. And then in going along with preliminary hearing is bound over. Sentencing, WebEx. People don't know what WebEx is. They think it's, you know, like if you say Zoom to them, they understand, but WebEx is just not something. In the chat, it says set aside. That's a good one. Continuance, objection, and then the sustained or overruled. Parole versus probation, criminal protective orders, sentencing protective order, continuous protective order. There's a million of them. I mean, every single day I have to ask one of the attorneys, usually Hillary, because she sits right there. what, what does this word mean? Especially if they're in Latin. Like, so is there any other terms that people can think of, or is there any of the terms that have been mentioned that people don't understand that we could explain really quick? Okay, so that is something that's, I mean, the criminal justice process and procedure is very, very confusing for somebody that's never been involved in it before. And even being involved in it, it's still very, very confusing. So the right to have things explained to them in a clear way so that they understand is one of, I think, one of the really important rights for victims in the criminal justice system. The next right is pretty self-explanatory, and that's the right to a secure waiting area. And that's just the right to have a waiting area that does not require the victim to be in close proximity to defendants or family or friends of defendants. At court, usually this is accomplished by a victim waiting in a conference room. At Matheson, they have little conference rooms off to the side of the well, all of the courthouses really have little conference rooms. It's just Matheson has a lot of them. So, and then it's usually on the victim advocate that's involved to get them in the conference room and kind of go back and forth, letting them know what's happened and getting them when it's time for their case to be called. That's another thing that I think a lot of victims don't understand, is that most of the time when we're in court, it's open court. It's a law in motion calendar. There's a million other cases going on, and they think they're just coming for theirs. So a lot of times explaining to them, hey, we might have to wait for a while till our case gets called, is important too. So yeah, that's a pretty basic right, but it's important. I think it's important for victims to feel like they're safe. I know a lot of times in court, I will make sure that I'm escorting victims to and from, that I sit on the outside edge of the bench so that, and I move my body accordingly so that people can't make eye contact and stuff. But the next right is the right to restitution or reparations, and or reparations. So the key word there is and or. Because just because a victim received reparations through a lovely UOVC does not mean that they can't ask for additional restitution. Restitution requests, though, are specific. There's proof needed that this restitution is needed. You need receipts or bills, that sort of thing, for restitution. It's completely different than asking for relief in a civil case. So if somebody were to sue the defendant civilly, then, they're just asking for an amount of money. It's not necessarily specific, but restitution and reparations both have to be specifically for things that are associated with the case. The next right is also pretty basic. It's just the right to have personal property returned. This refers to personal property that is taken for evidence during the investigation process. The property is usually not returned until the court case is over, until it's adjudicated, which we know in the criminal justice system could be years. So I know that is something. I just recently had a victim that was really upset because her gun was taken. And it's a federal case, so she's not seeing that gun for years. And she was really, really unhappy about that. I'm gonna skip employer intercession for now because I actually have another slide that deals specifically with that. So the next right that we have is the right to speedy trial and disposition. This is one that comes up a lot in our realm. This, of course, is a right that is also afforded to defendants. the thing that is important to remember is that within the criminal justice system, speedy is a very subjective term. Even though we want victims to be aware that this is their right, it's important to give victims reasonable expectations. Court can take years. We have, I mean, obviously this is a crazy one, but we have a case that the crime happened 40 years ago that's still in the process of things. We have cases that have been 5 years. We have cases that have been 10 years. And we have cases that have been 2 years, but it's important. A lot of times I will get victims that will say, oh, I want my right to a speedy trial. And it's been 6 months. And even though that's a really long time within the criminal justice system, it's not a really long time. That's nothing. So it's important to give victims realistic expectations of how long the criminal justice process can take. Again, if anybody has any questions or comments, please just break in. I love it. But the next one we have is a notice. Sorry, I got lost. Timely notice of proceedings. This is on pretty much usually on the prosecutor's office. So I'm sure we'll hear more about that today, but it's either through the victim advocates or, if nothing else, just getting the victim signed up to receive notifications about court proceedings to their email. It's really important with this right to note that it's if the victim wants to be informed about everything. So some victims, they don't want to know every single case that's going to happen. And so it's important to respect that and, still make sure they're informed if there's things that are really important, especially things that they have to be there for, which they should get subpoenaed for anyway. But some victims, they don't want that reminder constantly coming up in their email box every time there's a scheduling conference that gets continued or motion, an oral argument or motion that's filed. So the next right that I want to talk about is specific to victims of sexual assault. And that is the right to voluntary HIV testing and to request mandatory testing of the alleged sex offender. There's actually a lot more rights associated with testing and DNA in sexual assault cases, such as the right to be informed whether a DNA profile was obtained during the CODAR, or other crime scene evidence, being informed whether a DNA profile was entered into CODIS, and the right to be informed if a match is found in CODIS. Also, and this is really important, I think, to let victims know, is that they have a right not to be charged for a medical forensic exam. So I think a lot of people are terrified of going to the hospital. I mean, obviously you're terrified of going to the hospital for a SANE exam anyway, but then you have that added stress of being worried that you're going to get billed this horrible bill from the hospital. And that's actually one of the rights afforded to sexual assault victims, is not to be charged for that SANE exam. There's a lot more that's even more specific to sexual assault investigations. I'll add the link to, Kristen, love it. Okay, so Kristen just asked in the chat, sorry. I will put this in the chat in a minute so that you guys can see the rights, but Kristen just asked, why is testing limited to HIV? It should include HPV, herpes, and a full STI panel. Kristen and I 100% agree. And Hillary and I actually just had this conversation yesterday, because in my brain, I thought that it was HIV and STIs. But I got thinking about it when I have been at the hospital for a SANE exam with a victim. I remember the nurses saying that they follow up with their doctors for additional testing. I think the reason why it's specific to HIV is just because that's like the most life-threatening one, maybe. but that's just the statute as it is right now, is that it's just HIV, but I 100% agree with you, Kristen, that it should be everything. So maybe we better start talking to the legislatures about that. Is there any other questions? Lori, do you have a question, or is your hand still up from before?
Actually, I just have a comment on
Okay.
HIV testing. It's interesting because if a victim goes in and during their exam, if they want the medication to help prevent HIV, they need to do it. They need to take that, start that 28-day regimen within 72 hours. And so by the time they test someone, they don't have the results back. So it kind of misses the boat. It might be an interesting FYI, but they would have already had to have started the HIV regimen to have that help at all.
My concern, though, is the defendants being tested. I think the defendant should be tested for a full panel and not have it just limited to HIV. That's the only right that the victim has. Is that correct? Is to request that the defendant be tested for HIV? Is that correct?
That is the only mandatory one that they can request. Yeah. And Naomi just put a good comment in that it says the recommendation is now to do STI, STD testing at the time. The reason for the HIV testing is because we have to provide that testing to treat the patient for HIV prevention, which is what Lori was just talking about. Vicky says in the chat, if the victim got that additional testing for STI, the cost could be covered by crime victim reparations as part of their application from a SANE exam. Yay, Vicky. So we all know how amazing the advocates and the nurses from rape recovery and stuff are. They're so good at getting the applications for UOVC filled out right there at the hospital. So that is definitely something that a victim could get tested. The one thing that I kind of thought about yesterday is that maybe the reason why it's not in the statute is because it could go to victims' right to privacy. If they already had an STI, you know, that kind of opens things up for, and we'll talk more about this in a little bit, but it kind of opens things up for like defense counsel in the case, but it could go to their right to privacy as far as testing for other STIs and having that in a report that everybody's going to see.
I still am, but if I can, I'm still talking about the defendant being tested. The defendant only has to test for HIV. I think the defendant should be tested with a full panel to ensure.
Agree.
That's my thing. Okay, I appreciate it.
No, I 100% agree with you, Kristen. Like, I think that is really important. And I definitely think that's something that can be requested, because I know that there are charges that can come from like knowingly spreading sexually transmitted disease. So I do think it's something that can be requested, but it's not in the statute that it's mandatory. The only mandatory one is for the HIV. But Kristen, maybe we need to get on, I don't know, somebody with UDBC or something and have them get with a legislator and change that in the statute, because I think that is a great idea.
Yeah, I'd love to see that changed, just so that that victim has that level of protection too. The sexual assault is devastating enough, but you come away with herpes or something like that, I think that defendant should be held liable for that as well.
Naomi says in the chat, the state is moving towards contact tracing. It would be nice to hear how the health department is planning on doing with SA cases when the patient victim is the only one being tested, treated. That is a really good, yeah, that is interesting. Yeah, I think we need to find a legislator that wants to help with this, because I 100% agree with Kristen that it should be mandatory full panel. testing for a sexual assault victim, but also, or sexual assault defendant. That also goes to, and that it's something that you have to really worry about, goes to their rights as well. Like we talked about earlier, defendants have a lot more rights in the criminal justice system than victims do. So there might be some sticky stuff there, but definitely something to look into. And then the last one on there is the right to be present and heard in important proceedings. This is my favorite right. It's really, really important. The victim has the right to attend any and all court hearings if they want to, though they don't have to be there unless they've been subpoenaed. Victims have the right to be heard in important criminal proceedings. So what are important criminal proceedings? This would include things like detention hearings, which is determining whether or not somebody's going to be released from jail. Preliminary hearings, which obviously, a lot of times or most of the time a victim would be testifying in those. Trials, obviously, restitution hearings, sentencing hearings, motion hearings, if victim rights issues are being discussed in the motion hearings, and expungement hearings. Outside of those important criminal proceedings, the victim can ask to be heard anytime. It would just be at the discretion of the judge. So it kind of depends on how busy it is and what the judge has going on and what kind of mood the judge is in that day. But they can always ask to be heard in other proceedings. It just is up to the judge. Hang on. Gotta get my thing to change here. There we go. There are some additional rights that are afforded to children that are victims in the criminal justice process. So I'll just go over those really quick. The first is that children 13 years or younger shall be examined in age-appropriate language. And that's comes into like legalese and also using terms that are appropriate. And I know we've got people from the CJC that are going to talk today, so I'm sure that they'll talk a lot more about that. The court also can appoint an advisor who does not have to be an attorney. So sometimes we will get, like the clinic will get appointed in cases with kids, or sometimes we get asked by the prosecutor's office or the parents or whatever to be brought on, but it doesn't have to be an attorney. That's the advisor to assist a witness who's 13 years of age or younger in understanding the questions that are being asked by counsel. Lawyers, bless them, especially I feel like defense attorneys, sometimes they just don't know how to word things so that a little kid can understand. So there are advisors that can help with that. There's also that the investigation and other proceedings should be done in the least traumatic or intrusive way possible. And again, we've got somebody from the CJC talking later today, and I'm sure that they'll talk about fit interviews and open-ended questions and all of the wonderful ways that the CJC has developed to work with those child clients. Most detectives are also trained on how to do that. So interviews related to the investigation should be kept age appropriate again and kept to a minimum. They should have protection from physical and emotional abuse during their involvement with the criminal justice process. Children, and this one I feel like is the most important, children are not responsible for inappropriate behavior adults commit against them. And I feel like that is so, so important. Children are not responsible for the behavior that got them involved in the criminal justice system in the first place. They also have the right to be informed of available resources that might assist them. Again, CJC comes in really big in this because they do such a great job when the kids come in for an interview of talking about all those resources, but that's also important for victim advocates to give all of that information. And then to keep criminal justice center, or sorry, children justice center interviews confidential, but the court can determine who gets a copy and can impose restrictions. And that's kind of important. The criminal, or the, sorry, I keep saying criminal, the CJC interview can be used like in a preliminary hearing instead of making the child testify if the child is under 14, I think. And so then it would be, you know, kind of more public. There are also some rules of evidence that are different for child victims. So for instance, and we've just recently kind of started having some issues with this, but there are rules within the state statute about that I always thought just kind of applied to like DCFS and CJC and that sort of thing. But there are, like, if there's a medical report that's done because the child goes to the hospital for an abuse situation or something like that, that's going to be turned over to the detective, which means it's going to be turned over to the prosecutor, which means it's going to be turned over to the defense. There are ways to protect medical documents, and we'll talk about that more in a minute. But with child victims, it gets a little more sticky, protecting all of that stuff. Does anybody have any questions about the child right stuff? I think our CJC people will probably talk a lot more about that today, but as far as like child specific rights, does anybody have any questions about that? Okay. I was going to talk about employer intercession really quick because this is something I think that we don't talk about enough. There are specific rights for a victim to have employer intercession when they're involved with the criminal justice process. And that's things like if the crime happened, you know, at work, making sure that the employer isn't going to retaliate for that person reporting a crime. Workplace violence protective orders, which is a relatively new thing. And that's a protective order that an employer can file for that protects the whole workplace. Reiterate to the employer the importance and legitimacy and necessity of attending court, and that it is an appropriate use for paid time off. And then also to try to help coordinate schedules with the victim for hearings, prelims, trials, as much as we can, you know, as much as can be done. The prosecutor's office or victim advocates are going to try to make sure that that works out well for them. And then lost wages reimbursement for attending court through our lovely UOVC. Does anybody have any questions about employer intercession, or does anybody have any examples of how we can assist victims with their employers?
So I just literally wrote a letter for an individual that was scheduled to testify, subpoenaed to testify. I showed his employer that he was supposed to testify. There was a little pushback, so I wrote a letter on letterhead just explaining the importance of his participation, and of course thanked the employer for allowing that person to exercise their rights within the criminal justice system, and I think that helped.
Absolutely. I'm sure it did, Kristen. And that's one of the ways we can call the employer, we can send a letter just so that they know, hey, this is legitimate. This is really important. This isn't like a voluntary thing. This person has to be there. I mean, obviously they can always show the subpoena and stuff too, but sometimes it helps to just talk to the employer and be like, hey, just so you know, like, they have to be there. This isn't optional. This is absolutely an appropriate use for their PTO if they have any and kind of go from there. Anybody else have any comments on employer intercession or experiences with that?
Yes, I had a recent experience with a victim of domestic violence. Common law spouses living together, working together. She was a victim of domestic violence, strangulation, and all of that. She was the one fired from work. They were working in the same place, a restaurant. So she was fired. I guess he was more valuable for their boss. And when the following day, she was all bruised up and everything, and she was to work. The thing is that they went to work the following day. She was all bruised up. She didn't make the report. I ended up calling Draper PD. They took the report, but it happened in UPD area. So she told the boss what happened. They couldn't keep them working together. She was fired. When she called me, I called the employer. I referred her to contact your organization, and I have to follow up with her because this recently happened. It happens that she does not have immigration papers to work in the United States. So it sounds like the boss used that, saying, I don't want problems, the police presence in my establishment, and I don't want to deal with you, you don't have papers. So that's a tough situation with the immigration situation, with all the things going on. Well, she has all those expenses because now she doesn't have his support or his help to pay the rent and everything else. So yeah, those are the situations that we are seeing now. And when employers won't listen to anyone, they can do with their business whatever they want to or they need to do. So yeah, I hope that she reaches out to
I
some
hope
of you.
so too. You might send me a message so I know her name so that I can look out for her. That is horrible. That makes me so upset. And you make a good point. Like, employers can do whatever they want with their business, but that does go to, you know, making sure that the victim's not going to be retaliated against for reporting the crime. I definitely think that that is something that we can try to intervene in. Showing the jail release agreement or pretrial protective order to the employer and just being like, look, like, there's a domestic violence issue here. They can't be together, like, schedule them on different shifts or something. But also sometimes if things get far enough with that and they have to file a civil suit, there are attorneys. We're not, like, we only do criminal stuff, but there are attorneys that specifically have really good knowledge about employer, like employment law. So that's always a good route to refer people to those specific attorneys. And I know, like, one off the top of my head, but there are a few within the state. Okay. I thought I was going to be done in like 10 minutes and you guys were just going to be horrified, and I am not even close to done and I have like 15 minutes. So I'm going to move on. So I just wanted to talk a little bit about the victim's court experience. The most important thing to remember for a victim in criminal court is that the prosecutor does not represent the victim. The prosecutor represents the state or the city if you happen to be in a justice court. Many victims go into the criminal justice process thinking that the prosecutor is their attorney. The prosecutor is representing them. And so it's important to make sure that victims understand that the prosecutor is on their side, you know, is looking out for their best interests, but the prosecutor is representing the state. It's also really important, I think, for victims to realize that they're not pressing charges against, especially in a domestic violence, you know, situation, that sort of thing. They're not pressing charges. The state's pressing charges. I know that we have all had victims that have been pressed to drop the charges or waive the JRA or, you know, whatever. And it's really important for them to understand they can't drop the charges because they're not pressing the charges in the first place. And then a victim doesn't necessarily need legal representation within the criminal justice system, because again, they're not pressing charges. The times when they do is if there are victim rights issues. And that's when you call us, or the prosecutor can do some of that too. So the victim's court experience, the first thing that they usually go through is an intake with the DA, with the prosecutor's office. That usually involves a victim advocate, the prosecutor. It's pretty basic. They're going to get their contact info. They're going to find out what level of notification that they want, get them signed up for notifications. They're going to get their thoughts on the case. Just pretty basic. Get to know each other and get ready to start the process together. Other things that victims can be involved in, detention hearings. That is usually pretty early on in the process that there'll be detention hearings, and there can be multiple detention hearings throughout the process. But if the defendant has been arrested and they're in jail, they're going to have a detention hearing, or they're going to discuss detention possibly at the initial appearance. And that is a time when the victim has the right to speak and say whether or not they want the defendant to be released from incarceration. Another thing that victims have a lot of involvement with is the preliminary hearing. A preliminary hearing is, if you don't know, it's like a little baby trial. And it's when the prosecutor has to show that there is probable cause to bind the case over to go to trial. So most of the time, or a lot of the time, victims will have to testify at the preliminary hearing. We love 1102 statements in our clinic because 1102 statements are a written statement that the victim does that can be used in lieu of them having to testify at the preliminary hearing and having to be cross-examined. So that makes it so that we don't have to traumatize the victim by making them testify at the prelim and then potentially also having to testify at trial. We don't have to open them up to be cross-examined. A lot of times things that come out in cross-examination end up having effect on the case later on. So we love 1102 statements. The Salt Lake County District Attorney's Office has kind of cracked down on 1102 statements, and they have to have permission from a supervisor to do an 1102 statement. And sometimes it's kind of hard to get that permission, but that is something that you can always kind of suggest and advocate for with your clients to help them not have to have that additional trauma. Sorry, my phone's ringing. And I can't turn it off. The next thing that they can experience is motions and subpoenas. There are a myriad of different motions and subpoenas that can be put forth during a criminal case. Two of the most important, as far as victim rights go, are what's called a 14B motion or 412 motion. A 14B motion refers to the rules of criminal procedure, Rule 14B. And it goes to a victim's right to privacy. A 14B motion is usually a request from defense counsel for private records, such as medical or mental health records. And that is something that, a victim absolutely has a right to privacy. They have a right not to have all of those records put out there. So normally the defense will file a motion, prosecutors will object to it. If we're involved, we'll object to it. There's a hearing, the judge determines whether or not the records can come in, and then they can ask for what's called an in-camera review, which is the judge going through and redacting anything that's not relevant to the case. The second motion that comes up a lot in cases with victims is a 412 motion. That refers to Utah Rules of Evidence 412. It's better known as the Rape Shield Law. In short, according to Rule 412, a victim's sexual history and proclivities cannot be brought in at preliminary hearing or trial unless defense can prove in the 412 hearing, which is also called a rape shield hearing, that it goes to the defendant's due process rights. And I do actually have a slide, if we can get to it, where it talks about that in a little bit more detail. Also, under the new Supreme Court ruling in State v. Jolly, a victim cannot be compelled to testify at a rape shield hearing. So a victim does have a right to be heard at the rape shield hearing, but the new ruling in Jolly means that they can be subpoenaed to testify and they can't be cross-examined. There's a lot of other motions and subpoenas that can be filed. I mean, millions. But those are some of the most common that we deal with as far as victim rights concerns go. And both of those are examples of motion hearings where a victim has a right to be heard. The next thing that a victim deals with in court is plea deals and sentencing. Victims have the right to have the process explained. So best process is usually for the prosecutor to talk about any plea deals with the victim, get their input on it, see how they feel. They can object to a plea deal. It's not usually very successful, but they can. And hopefully, you know, the prosecutor will listen to what the victim has to say, but it is ultimately up to the prosecutor what plea deals are offered. The other is sentencing hearings. Sentencing hearings are really important because that's where a victim gets to do a victim impact statement. And I have seen victim impact statements completely change a judge's mind, or at least influence really heavily what we thought was going to happen with sentencing with a judge. They're really, really impactful. They're very important. And it's not only important for the criminal justice process and for potentially having sentencing go better than it would have without it, but it's also really important for the victim's healing to have their voice be heard and their story told in that point. There's also appeals and expungements. The victim has a right to be told about expungements, requests for expungements and appeals, and they could have the right to be heard in those proceedings. Also 402 reductions, which is like reducing the severity of a crime, is another one. Sorry, I'm like running out of time. Does anybody have any questions about any of the common court experiences for victims? Okay. So I have some scenario things I wanted to try to do really fast. So Jane is the victim in a domestic violence aggravated assault case, a second-degree felony. The defendant, her husband John, has made threats against Jane from the jail in the presence of law enforcement and to his defense attorney. Jane has been thinking of waiving the jail release agreement so that she can talk to John about their kids. The defendant has his initial appearance in court coming up, and detention will be addressed at that time. Defense counsel has also filed a Rule of Criminal Procedure 14B motion to get records from the therapist Jane has been seeing. What are the victim rights issues here, and what can be done to assist the victim? Throw it out there. I'll start calling on people. Okay, Anya says needs to be informed of threats. Yes, absolutely. Anybody else? I'll just go, I'll click on it really fast because we are running out of time. So yes, right to be made aware of threats. Jane should be told about the threats John has made against her so she can make an educated decision about the JRA. A pre-trial protective order should also be requested at initial appearance hearing. This is pretty standard for a DV case. Victim can ask for contact to be allowed or restricted, but still be protected from violence. Also, the right to timely notice of proceedings and the right to be present and heard at important proceedings. She has the right to be told about that initial appearance and that detention is going to be addressed, and she has the right to be heard on whether or not she wants him out of jail. Also, the right to privacy. Jane has a right to privacy regarding the defense request for her personal therapy records. In opposition to the 14B motion should be filed, a hearing held to argue the motion, and if the judge does decide to allow, an in-camera review should be requested. Okay, bonus points. John is convicted and sentenced to prison time. What are Jane's rights regarding the sentencing hearing? What does state statute say that she now gets? She's now insured. Does anybody know?
She can get a continuous protective order.
Kristen, I love you. Yes. State statute says that if a defendant is sentenced to incarceration, which is jail or prison, in a domestic violence case, the judge shall, there's that important word again, shall put in a continuous protective order. Restitution is also a shall. Sometimes we need to remind the prosecutor that they need to mention that in any plea deals, that sort of thing. Jane also has the right to be heard at the sentencing hearing to give her victim impact statement. Really fast. Mary is the victim in a sexual assault case. She went to the hospital the night of the incident and had a SANE exam. The person who assaulted her has been arrested and is being held without bail, thankfully. Defense counsel has filed the Utah Rules of Evidence 412 motion, rape shield statute. They want to talk about Mary's previous sexual history and her interest in BDSM in the trial. A hearing for the 412 motion is coming up, followed by the preliminary hearing. Mary has already missed work after the incident and to attend a detention hearing. Mary's employer is giving her a hard time about missing work for more court hearings. What are their victim rights issues and what can we do to help? Sorry, we really are running out of time. So she has the right to the HIV testing and STI testing if she asks for it, and it can be paid for, and the right to compel the defendant to the HIV testing. She also has the right to privacy and to be treated with dignity and respect. So that's where the 412 rape shield hearing comes in. There are specific things that the defense has to meet for there to be an exception to bringing in those sexual proclivities or sexual history. And that it has to meet one of the three exceptions: evidence of specific instances of victim's sexual behavior if offered to prove that someone other than the defendant was the source of semen injury or other physical evidence; evidence of specific instances of the victim's sexual behavior with respect to the person accused of the sexual misconduct if offered by the defendant to prove consent; and then evidence whose exclusion would violate the defendant's constitutional rights. And then also the right to employer intercession. And then the last one I was going to throw really fast is ES is a child sexual assault victim. They were interviewed at the Children's Justice Center, didn't have to testify at the prelim. The trial is coming up and ES will have to testify. What are the rights? And then you had the victim rights that they can be questioned in an age-appropriate manner, that the court may appoint an advisor, that investigations and other proceedings should be done in the least traumatic or intrusive way possible, that child victims are not responsible for the inappropriate behavior, and that they have a right to have interviews kept to a minimum. Also, a couple of little extra things. Children may be allowed to have a comfort item when testifying, like a stuffed animal. And they may be able to testify via closed circuit, meaning that they can testify in real time, but virtually and either out of the presence of the defendant and or jury. Anybody have questions, comments, funny stories, anything?
Fantastic presentation. Thank you. Very informative.
Well, thanks, Kristen. I appreciate you. If you have any questions or concerns, if you have a situation that comes up with a victim and you just aren't 100% sure what their victim rights are, please call the clinic or email me. I've got my contact information here. Emailing is usually easier because we're kind of in and out of the clinic a lot. But please, please contact us. I love to talk to other victim advocates, and we want to help in any way that we can. Thanks, everyone.
Thank you so much, Launi. We really appreciate you and your time. And then we will take a break until 10:15 and come back then.